Good morning and welcome to Citizen Extra. I am Ann Kiguta. We're following for you news wherever it breaks in the country and around the world. Today we're following two very key decisions from the courts. We are live for you at the Supreme Court here in Nairobi and also the Milimani Law Courts, where we will be expecting a decision on one hand and a hearing to commence on the other, both surrounding the election on August the 8th. We'll be giving you details on that very shortly. Our reporters are standing by and we'll be bringing you those updates live. We're also live for you in Meru this hour. Our reporter Jamlek Maina is embedded with the presidential campaign team. He is following Jubilee's vote hunt in a region that has been called a swing county. Is that the case? We'll be talking to him very shortly. But first, let's take you straight to the Supreme Court, where Francis Gashuri is standing by. As I alluded to earlier, there is a ruling that is expected this morning in an appeal that is contesting a lower court's decision on the final declaration of presidential election results at the constituency level as final. Francis, good morning to you. What can you tell us as parties prepare to hear the decision of the courts?
Good morning, Auntie Guta, and good morning to all our viewers. In about 5 minutes or so, the five-judge bench will be assembling to make a very important ruling that will have a key influence on the conduct of the general election on the 8th of August and eventually the announcement and declaration of the presidential result for that particular poll. Remember, there are 8 candidates in the race for the presidency, and so the matter that is before the five-judge bench led by Justice Milton Makandia is whether the presidential election results announced at the constituency level will be final or they are subject to verification and eventual tallying before declaration by IEBC chairman at the National Tallying Center here in Nairobi. It is the position of the Independent Electoral and Boundaries Commission that IEBC chairman is the returning officer of the presidential poll, and so he has to receive all the presidential election results coming from all the polling stations, all the constituencies, all the counties, and verify them before declaring them at the National Tallying Center. On the other hand, it is the position of Katiba Institute and the position of National Super Alliance NASA that the constituency results announced at the constituency level are final and are not subject to any verification or any alteration unless by a court order. And so that is the contest that the five-judge bench will be arbitrating, or the five-judge bench has been arbitrating and will be making its verdict this morning. And so the lawyers for various teams have already assembled at the Court of Appeal. Remember, the Court of Appeal is housed here at the Judiciary Headquarters, where also the Supreme Court is housed. And so the five-judge bench that comprises Justice Milton Makandia, Justice Patrick Kiage, Justice Agnes Murgo, Justice Agnes Murgo will be making that declaration this morning. Kaduri Mamtoinoti also in that bench. They will be making that declaration whether the results announced at the constituency level will be final. And remember, and however the ruling goes, there is a possibility that any of the aggrieved parties will be moving to the nearby court, that is the Supreme Court, if they are dissatisfied with the decision that will be made by the Court of Appeal judges. So it's a very, very critical ruling this morning, and that's why we're here to tell our viewers how the cookie will be crumbling on.
Yeah, Gashuri, before we let you go, I just want you to break down the stakes for us a little further, because even though you've said that there is, of course, a possibility of a further appeal on this decision, should it not go the way in which IEBC would hope, which would be that the constituency results would be still subject to further verification and a presidential vote announcement coming from the chairman himself, what would it mean for the commission in terms of, you know, just being absolutely certain that the presidential result at the constituency level is safeguarded and is beyond reproach?
And when the lawyers for the IEBC were making their submissions before the five-judge bench, they made very compelling remarks that, for example, lawyer Paul Nyamodi representing IEBC as well as Wambua Kilonzo representing the Electoral Commission were arguing that the chairman of the Independent Electoral and Boundaries Commission, IEBC, is the returning officer for the presidential vote. And that's why all the presidential aspirants then submitted their nomination papers to him at the KICC, and that's why he cleared them to run because he is the returning officer for the presidential vote. So he's arguing, or the IEBC Commission is arguing that if you were to have the results declared at the constituency level as final, then you would be taking the powers of the chairman of IEBC as the returning officer and handing them over to the constituency returning officers, whose mandate is to take charge of the elections at the constituency and eventually declare the results for the members of the National Assembly and escalate the results for the other positions to the respective returning officers. That is, for example, the woman rep, the senator, the governor, and the presidency to the respective returning officers. And on the other hand, the NASA team and the Katiba Institute have argued that IEBC is not necessarily the chairman, and that all the returning officers appointed by the commission have been vetted, have gone through a process of clearing them to make sure that they are people of integrity. And so there should not be any fear that the returning officers in the constituencies are going to alter or falsify the results that will be coming from the constituencies. And that's why they insist that the results should be final, and that previous elections, when the results were tabulated at the constituency level and escalated to the national level, that's why they argue monkey business was being conducted. And so the five-judge bench has a responsibility now to tell us, from all these arguments, which way the decision will be, especially on how the presidential results will be declared, whether they will be declared at the constituency level or at the national tallying center.
All right, thank you very much. Francis Kashuri reporting for us live from the Supreme Court, and we'll of course be going live to that location a little later once the ruling commences. We want to catch up with a bit of more news that we're following for you this hour, which of course is Jubilee's vote hunt. They are in Meru today, and of course will be wooing area residents in a region that has seen some discontent over the last year or so. Some would say that the cookie began to crumble with the issues surrounding the Mira ban and the inability, some would say, of the administration to deal with it effectively. Jamlek Maina is on location for us. He's been following Jubilee campaign throughout the country. Jamlek, good morning. We saw yesterday, at least in Nyeri, a lot of residents saying, whereas they support the president and will be voting Jubilee in that respect come August, that when it comes to local politics, that they want the ability to make their own decisions, to choose their own leaders. And of course, that is a situation that has been augmented by the independents in the race. What scenario are we expecting today as Jubilee heads into Meru?
Indeed, good morning to you and Kiguta in our live studios back in the city, and clearly, as you said, in Meru County, where the President Uhuru Kenyatta, accompanied by his deputy William Ruto and a battalion of Jubilee leaders from this region and the Mount Kenya region, as well as Jubilee aspirants, are expected to tour various areas of this county for 2 days. Remember, he will be here today and tomorrow, whereby he's expected to tour a total of 16 stopovers. Today being the first day in this county, the president will be covering a total of 7 stopovers, which will be culminated by a meeting with the youth at Kemu University later on in the day. But in the course of the day, he will be touring various stopovers, addressing residents, roadside rallies, and also proceeding with launching several development projects in this area. And tomorrow, he will also be touring a total of 9 stopovers, whereby at the end of it all, he will be having a major political rally. So in total, he will be touring a total of 16 stopovers in Meru County, and the Jubilee battalion will be here in this county for 2 days. Remember, he started the Mount Kenya region tour on Sunday in Kiambu. He was there for 1 day, then he went to Murang'a for 1 day, then he was in Nyeri yesterday for 1 day. But maybe considering the vast in size of this county, he will be in Meru County for 2 days, that is today and tomorrow. It is a county that pundits say that both coalitions, the Jubilee coalition and the opposition, have a quality or quite a fair share of support, considering that the Nyambene area of this county seems to warm up for the opposition, while other areas seem to warm up for the leading coalition or the leading party, that is Jubilee. When we try to look deeper into some matters here, we remember that the incumbent governor of Meru County, that is Peter Munya, is vying or defending his seat using the PNU party, and he is also the PNU party leader. But on the other hand, the Meru senator, the incumbent Meru senator Kiraitu Murungi, is also vying for this seat under the Jubilee party ticket. So it is an area that has attracted stiff competition amongst the two leading coalitions, and what we're waiting to see is what the president will have to say about all these issues, because we saw in other areas he went around saying that he wanted leaders who are vying under the Jubilee ticket to be elected. However, you see, some of these other parties are friendly to the Jubilee coalition or to the Jubilee party, and they are also declaring their support for the re-election of President Uhuru Kenyatta come the general election. So what we are doing at the moment, we are just waiting to see what will transpire on this end, because he will be here for 2 days, accompanied by a battalion of Jubilee leaders. He will be starting off at Igoji, flowing all the way, a total of 7 stopovers scheduled for today, then another 9 stopovers tomorrow, which will culminate into a total of 16 stopovers in Meru County for the 2 days that he will be here. So we are waiting to see what will transpire, and basically we'll put our foot on the ground to ensure that we bring the viewer up to speed with everything that will be transpiring from this end. And from Meru County, my name is Jamlek Maina. Back to you and Kiguta in studio.
Thanks very much, Jamlek, and certainly it will be interesting to see if the president does insist on a 6-piece voting line, and in particular, of course, campaigning for his man who's eyeing the gubernatorial seat, Kiraitu Murungi. We'll be catching up with you a little later. My eyes are also peeled at the Milimani courts, and I wonder if we have that picture for you ready. This, of course, is going to be a key location to follow today. There is the ballot papers printing row that is ongoing. You'll remember, of course, yesterday NASA went to the Milimani courts, basically contesting the award to the Al Ghurair, if you want to call it that. There's all sorts of pronunciations to that word. Nonetheless, a Dubai-based printing firm. They are contesting the award of that tender to the firm by IEBC. You'll remember that it had been earlier, removed by court, but IBC went ahead again to re-award the same firm. So if we have these pictures, let's listen in to the Milimani courts a little bit.
But the bottom line, my lord, is this. This is a matter of critical importance, not just to the parties, but to the whole country. My learned friend is Swiss, but here that is also important to the world. I'm not convinced that way. But it is of critical importance, definitely to the country. So every step, my lord, in this matter.
All right, submissions beginning there, but let's bring you what is breaking news right now, the delivery of a ruling in the case at the Supreme Court, of course, surrounding the announcement of the presidential result. Let's listen in.
Nor was it an empty ritual. Rather, it was an epochal moment pregnant with meaning and significance, and speaking to the indomitable will of the people to take charge of their destiny and bend the arc of history to align with their most cherished aspirations and ideals as to how they wished to be governed and organize their affairs. Theirs was doubtless the most momentous act of sovereignty and self-determination since independence. And in the Constitution, they declared the birth of a new dispensation founded on the essential values of human rights, equality, freedom, democracy, social justice, and the rule of law. And it is no accident that Chapter 1 of the Constitution proclaims the sovereignty of the people, the supremacy of the Constitution, and imposes on every person a solemn obligation to respect and defends the Constitution. The Constitution goes on to declare that our republic is a multi-party democratic state founded on the national values and principles of governance captured in Article 10. These values are not mere suggestions or aspirations to be attained at some future date by generations yet unborn. They are directory and obligatory principles that are immediately and presently binding on all state organs, state officers, public officers, and all persons whenever any of them apply or interpret the Constitution, enact, apply or interpret any law, or make or implement public policy decisions. They are broad and all-inclusive in their reach, sweeping in their sway, and peremptory in their command. They include but are not limited to, and I quote, 10 subsection 1a, patriotism, national unity, sharing and devolution of power, the rule of law, democracy, and participation of the people. And C, good governance, integrity, transparency, and accountability. Close quote. The people of Kenya arrived at these principles out of a studious consideration and appreciation for the travails and trials of our nationhood and the struggles and sacrifices that they and their heroic compatriots had made to bring freedom and justice to our land. They were also keenly aware that the ties bind them in united nationhood are periodically stretched and strained at election time, and so sought to insulate the election process from the deleterious perils and malaise of opacity, corruption, crime, and malpractice. The antidote they prescribed was an electoral system founded on and infused with clearly defined core principles, including, in particular, free and fair elections that are conducted by an independent body, are transparent in character, and administered in an impartial, neutral, efficient, accurate, and accountable manner. This appeal, as were the proceedings giving rise to it, are a call to the judiciary to authoritatively pronounce on whether these constitutional principles are upheld and given effect to, or are violated and infringed by certain provisions of the Elections Act, and we'll refer to it as the Act from here on, and the regulations made thereunder, insofar as they relate to the results of presidential elections. It is a question of first importance that implicates this Court's understanding of electoral accountability, the sanctity of the vote, the giving effect to the will of the people in the manner of elections as its overall constitutional philosophy. The appeal arises from the judgment and decree of a three-judge bench of the High Court, that is the Justices Mchelule, Korir, and Mwita, delivered on the 7th of April 2017. The judgment was rendered in a constitutional petition filed by Maina Kiai, Khalif Khalifa, and Tirop Kitur, that is the first, second, and third respondents respectively, against the Independent Electoral and Boundaries Commission, the appellant, and the Attorney General, the fourth respondent. The petition was filed pursuant to Article 165, subsection 3D of the Constitution, and sought declarations regarding the constitutionality of provisions of the Act and the Elections General Regulations 2012, which we'll refer to as the regulations hereafter, which are specified below. The petition was brought against the appellant as the body charged under Article 88 of the Constitution with the responsibility of conducting and supervising free and fair elections in Kenya. For his part, the fourth respondent was sued in his capacity as the principal legal advisor to the government who is also responsible for representing it in legal proceedings and for promoting, protecting, and upholding the rule of law and defending the public interest. The first, second, and third respondents prayed for the following reliefs in their petition, and I quote: A declaratory order that sections 39, subsection 2 and 3 of the Elections Act 2011 are contrary to the provisions of Article 86 and 138, subsection 2 of the Constitution, and are therefore null and void. B, a declaratory order that regulations 83, subsection 2, 84, subsection 1, and 87, subsection 2 of the Elections General Regulations 2012 are unconstitutional and contrary to Articles 86B and C and 138(2) of the Constitution, and therefore null and void. C, a declaration that respective constituency returning officers are the persons responsible for the conduct and declaration of constituency presidential election results. D, a declaration that constituency presidential elections results, once declared and announced by respective constituency returning officers, are final results for the purposes of that election. And E, a declaration that constituency returning officers possess a fundamental and an inalienable mandate to announce and declare the final results of a presidential election at constituency level, and that such declaration is final and is not subject to alteration, confirmation, or adulteration by any person or authority other than an election court pursuant to Article 86 and 138(2) of the Constitution of Kenya. Close quote. The appellant and the fourth respondent opposed the petition on the grounds that the High Court did not have jurisdiction to hear and determine the matter because the question raised therein related to presidential elections which were exclusively reserved by the Constitution for the Supreme Court, that the issues raised in the petition were res judicata, having been raised and determined in the case of Raila Odinga and 2 others versus IBC and 3 others, and that in any event the impugned provisions of the Act and the regulations were not unconstitutional. Before the hearing of the petition, the fifth respondent, Katiba International, a legal non-governmental organization focusing on the implementation of the Constitution of Kenya, applied and were admitted to the petition as amicus curiae and permitted to make written and oral submissions on the dispute. The petition was subsequently determined on the basis of the pleadings on record as well as written and oral submissions. Upon hearing the parties, the High Court held that it had jurisdiction to hear and determine the petition, and that the issues raised in the petition were not res judicata, and allowed the petition in the following terms, and I quote: A, it is declared that to the extent that Section 39(2) and 3 of the Elections Act provides that the presidential elections results declared by the constituency returning officers are provisional, it is contrary to Article 86 and 138(2) of the Constitution and is therefore null and void. B, it is declared that to the extent that Regulation 87(2)(c) of the Elections General Regulation 2012 provide that presidential election results declared by the constituency returning officer are provisional, it is contrary to Article 86 and 138(2) of the Constitution and is therefore null and void. C, it is declared that to the extent that Regulation 83(2) of the Elections General Regulations 2012 provides that presidential election results declared by the constituency returning officers are subject to confirmation by the Commission, It is contrary to Articles 86, 138(2) of the Constitution and is therefore null and void. D. It is declared that the presidential election results declared by the constituency returning officer are final in respect of the constituency and can only be questioned by the election court. And E. It is declared that to the extent that the first respondent interprets Section 39(2) and 3 of the Election Act and Regulations 83(2) and 87(2)(c) to mean that it can confirm, alter, vary, and or verify the presidential election results declared by the constituency returning officer, in particular constituency, it is contrary to Articles 86 and 138(2) of the Constitution and is therefore null and void. Close quotes. The appellate was aggrieved by the judgment and decree of the High Court and lodged in this court an appeal founded on 23 grounds, which ultimately they condensed into 4 broad grounds, contending that the High Court erred by A. misapprehending the law regarding the constitutional and statutory requirements for declaration of results of the presidential elections, B. declaring Sections 39(2) and 3 of the Act and Regulations 83(2) and 87(2)(c) unconstitutional, null and void, C. holding that it had jurisdiction to hear and determine the petition, and D. holding that the dispute was not res judicata. Arguing the first ground, the appellant's learned counsel, Mr. Nyamori, Mr. Kilonzo, and Ms. Ewang raised the following 3 issues, namely, the difference between announcement and declaration of election results, the person responsible for declaration of the result in a presidential election, and the purpose and effect of Sections 39(2) and 3 of the Act. On the first issue, counsel submitted that to appreciate the meaning of and the difference between announcement and declaration of election results, the context in which the 2 terms are used in the Constitution and the Act must be appreciated. They contended that announcement of the election results as used in Article 86(c) of the Constitution and in the Act and Regulations means making the results of an election publicly known. On the other hand, declaration, as defined in Black's Law Dictionary, 9th edition, means, quote, a formal statement, a proclamation, an announcement, especially one embodied in an instrument, close quotes. Relying on the judgment of the Supreme Court in Hassan Ali Joho and another versus Suleiman Said Shabal and 2 others, the appellant submitted that a declaration is a formal pronouncement in the election process by a person authorized either by the Constitution or the law to make the declaration, which pronouncement brings the electoral process to an end. Accordingly, it was contended that the appellant's chairperson, who is usually appointed via a gazette notice to act as the returning officer in a presidential election, is responsible for declaring the results of that election. In the appellant's view, an announcement of election result merely publicizes without finality the result of a particular election, but the declaration of results has the effect of determining the outcome of an election and bringing the electoral process to an end. On the second issue, the appellant submitted that the Act empowers it to appoint returning officers to supervise the conduct of elections for various offices. The appellant further submitted that under Regulation 3(1), the constituency returning officer is appointed to supervise the conduct of elections for members of the National Assembly and the County Assembly, while the county returning officer is appointed under Regulation 3(4) to supervise elections of governor, senator and woman representative. The appellant therefore contended that the returning officer referred to in Article 86C is any returning officer appointed by it for purposes of supervising the conduct of an election, while for the purposes of the presidential election, the returning officer is its chairperson. Referring to Article 138(3)(c) and 10, it was urged that the same vests a duty to declare the results of the presidential elections in the appellant and its chairperson. In the appellant's view, a correct reading of these provisions demonstrates that the constituency returning officer has no mandate to declare results of a presidential election. The appellant relied on Hassan Ali Joho and another versus Suleiman Said Shabal in support of the contention that it is only its chairperson who has the mandate to declare the results of the presidential election. Accordingly, in the appellant's view, the conclusion by the High Court that the results of the presidential election announced by the returning officer in the constituency are final amounts to extinguishing the constitutional mandate of the appellant and its chairperson. Turning to the third issue, the appellant urged that the Independent Review Commission, that is the Kregler Commission, appointed to investigate all aspects of the 2007 presidential elections in Kenya, recommended that election results be declared final only after proper scrutiny and verification. It submitted further that Article 138(3)(c, as read with Article 138(10), emanated from that recommendation, and that Section 39(2) and 3 of the Act and Regulation 83(2) were intended to give effect to those constitutional provisions. It was the appellant's further contention that the High Court erred by failing to consider and appreciate the purpose and effect of Sections 39(2) and 3 of the Act before holding that those provisions were unconstitutional. As regards the presidential election, it was the appellant's view that Article 138 is self-contained and that there is no need to look at any other provision of the Constitution. That article, it was submitted, does not apply to elections of any other office save the office of President, a distinction that the High Court failed to appreciate. Regarding Article 86, the appellant submitted that its purpose is to set out the constitutional principle that election results should be announced promptly, and that Article 138(2) does not provide for the manner of declaration of presidential results. The appellant maintained that in a presidential election, the only act that takes place at the polling station is counting and announcing of the results, with the verification and tallying being escalated upwards. Lastly, the appellant submitted that the constituency returning officer is not mandated to declare the results of the presidential election, that the High Court assigned to him a role not contemplated by the Constitution, and that upholding the High Court judgment would mean that in a presidential election there would be 290 returning officers, 290 declared results, and possibly 290 election petitions and 290 respondents, which would be impracticable and an absurdity. Moving on to the second ground, the appellant submitted that Article 138(3)(c requires it to verify the count before declaring the results of the presidential election, and for that purpose its chairman is required to tally and verify the count from all polling stations before declaring the result. In its view, the legal definition of the phrase to verify is, and I quote, to prove to be, to confirm or establish the truth, or to authenticate, close quotes, and not to alter and or vary results as was interpreted by the High Court. It was the appellant's contention that ballot papers are election materials which must be accounted for, and that the confirmation, verification, and collation carried out by its chairperson is a control measure to ensure that what is received from the returning officer at the constituency tallying center, as provided under Article 86B, is consistent with the election materials that were issued for purposes of conducting the election. According to the appellant, therefore, the collation, tallying, verification, and confirmation of presidential results is a purely mathematical exercise for the purposes of consolidating the results received from each returning officer, and that it is on that basis that the results are referred to as provisional. As regards the constituency returning officer, the appellant maintained that his role is to collate and publicly announce the results from each polling station in the constituency in a presidential election in line with Article 138(2), and to deliver it to its chairperson, the collated results, which he is in turn tallies and verifies in line with Article 138(3)(c) before declaring the result in accordance with Article 138(10). On the penultimate ground, the appellant submitted that under Article 163(3)(a), the Supreme Court has exclusive jurisdiction to hear and determine disputes relating to the election of the President. That jurisdiction, it was contended, was not shared with the High Court, and the High Court therefore erred in arrogating itself a jurisdiction that it did not have. In support of that submission, the appellant relied on